First, you'll notice on the roll sheet that some of your names have changed where they are, so be careful. Don't just go back to your normal spot and say, oh, that's me. Look for your name. Second, I have your causation exercises. I'm very proud of myself. They were due on Friday, and I have them back to you on Wednesday, so good for me. If you haven't seen it, there's a model answer available on Blackboard as well. For the most part, you did great. You spotted the key issues and argued them well, and sometimes there were arguments on both sides. And the fact that you may not have matched the answer or the analysis in the model answer doesn't necessarily mean yours was quote unquote wrong, but your individual comments may give you more information on that. If you have questions after you see your comments, let me know. If yours is not here, then definitely let me know, because that means there was some glitch, and we'll figure out what that glitch was, but these are certainly all the ones that I think I had. So that was that. You will also see on Blackboard, if you look, that there is a new exercise up, which we will talk about at the end of class, but I will tell you two things about it now. First, unlike the first two, this one is mandatory. This one you must do. If you don't do it, well, that'd be a real problem, given what I'm about to tell you. But A, you'll actually lose participation credit rather than gain it. If you do it, which you will, then you will gain participation credit. The second thing I want to tell you about it, besides it being mandatory, is that you're going to do it in teams. I have divided you into teams of either 3 or 2. We didn't divide evenly into teams of 3 because there were 65 of you. So there are 22 teams. 21 of those are teams of 3, and one group is a team of 2, as you'll see. And so one of the things that we want to sort of get into the curriculum and in you is the idea that as a lawyer you will have to work collaboratively. You'll have to work with other lawyers on a case, other lawyers in your firm, in your office, and so welcome to that reality. Some of you may not like team exercises. You may not like team assignments. You may have hated them in college. I know I personally did, because my thing was I didn't like to depend on somebody else who might not want to work as hard, who might not care, who might only be in the class because they had to take it, whatever. And so I wanted to just be responsible for my own grade. So I get it if it's not something you particularly like. Well, unfortunately, if that's how you feel, this is the reality. Sometimes you'll have to work with people out there in the world who will be slackers, who will disagree with you, who will fight with you, who will not be cooperative, etc., etc., etc. So, unfortunately, this assignment sort of may show you that reality. Hopefully it won't. Hopefully it'll be a good exercise, a good experience in collaboration, but you'll have to wait and see how it works out. So it will be due a week from today. A week from today, Wednesday, whatever date that is, October 3rd, I think. Okay, October 3rd. And you can either bring it to class that Wednesday, and you only hand in one, the team's answers. Or one of you can email it to me, but it has to be emailed to me by the time class starts on next Wednesday. Okay? Any questions about that? Obviously, you can't ask me questions about the substance because we haven't covered the material yet. But when we get to it, I'll show you what the assignment is. Yeah?
Where can we find what our teams are?
That is on Blackboard.
Oh.
The two things on Blackboard are the exercise itself and your team assignments. Okay? Anything else? Oh, by the way, one other thing about that. Not only will you get class participation credit for finishing this, the team that does the best job will also get a separate prize. Because Professor Rossini is not the only one who can play that game. Okay? It won't be like a real ridiculous prize, but it'll be something. Okay? Anything on your minds? to tell you that this is perennially people's nightmare class. People in this class hate impossibility. Okay? So fasten your seatbelts. Might be a bumpy ride, but we will make it through this ride together, I promise. And we start with Booth. Okay? But Booth is not the first protagonist in this case. The first protagonist is a guy named Charlie Stanford. Somebody tell me about Charlie Stanford, if you can.
Okay, so Charlie Stanford was a pretty well-known thief circa 1964. He boasted to have had 8 pages of arrest records extending over 15 years.
And it
pretty
pretty
well
much
known.
covers everything short of killing someone.
Yeah.
Okay? And in this case, although he seems like a pretty shady character, he's not the defendant. What is he?
He took part in a sting operation, I suppose, to...
But the sting operation started
as
with him committing a crime, of
Right.
course.
Yeah.
What was that?
He was walking through a YMCA parking lot in Oklahoma City, and he saw a gray cashmere coat that he just had to have, so he jimmied the door and relieved the owner of his gray cashmere coat, or the car, rather. So he stole a coat out of the car.
And did he plan on keeping this? Was that his idea? Was he like so in need of a cashmere coat that this was just like his life's dream come true?
Everybody.
No, I think he had Mr. Booth, the defendant, in mind. He called him up and said, "Hey,
I got a customer for this thing."
Yeah.
And his customer was Booth.
Uh-huh.
And who was Booth to Stanford?
Who was his attorney?
Was his attorney.
Oh my God.
Character fitness.
Okay. Well, yes, there are character fitness issues for sure. Now, this is a moment to pause and reflect on the profession you are about to join. All right? You want to not be one of the Booths of the world, of the lawyering world. Right? This is like one of those examples of the person you can sort of say, that's my anti-example. That's my not role model. Because Booth is like, in so many ways, not an exemplar of the profession. And he said to Booth, what did he say to Booth when he called him?
I got your coat. Like
I got your coat. So it seems like this has been set up in advance. Booth said, if you ever find a coat like this, I'm your guy. Because this didn't come out of nowhere, okay? And he said, and what did he say? He said, I got your coat, and
I'm going to need $20 for it.
$20 for a cashmere coat. Now, Stanford's probably got a market with that, right? That's a pretty good price.
Yeah.
Even in the 60s. So Booth said, I'll come over late tonight and I'll get the coat. All right. That was Booth's big mistake. Why? What happened between the phone call and 11 o'clock that night?
So the owner of the car realizes that his coat's missing. He calls the police. Oklahoma City Police Department Lieutenant Anthony comes and takes the report about the coat. And a couple hours later, he happens to see Mr. Stanford walking down the street in this gray cashmere coat.
Oklahoma City Police must be just amazing,
Telling it.
right? I mean, it's like they take a report and hours later they see the stolen property. It's incredible. Does it make you think that maybe there was more to this than meets the eye?
Yes.
Did that occur to you when you were reading this? That it probably wasn't a coincidence that Stanford may have been setting up Booth even before, and there's something going on here. It's too much of a coincidence. At least it's always seemed that way to me.
Yeah.
But in any event, they say he confesses that he got the stolen coat. Anthony had been investigating this burglary, right? Because that's all that Oklahoma City Police have time for is burglaries in cars. The rightful owner is identified, and they restore the coat to the rightful owner. Right? They call the owner in and say, "You got your coat." What does the owner let them do?
He lets him keep it as evidence, right?
As evidence? Yes, eventually. But what happens with the coat first?
Also to use it for the steam.
A little louder.
Allow for them to use it for the steam on the.
That's right. Right. He says, take it back to Stanford. Stanford can use it, and the police hide in a closet, right? So Booth comes in, and Stanford asks him for the $20. And this is my favorite part of the case. What does Booth say when he's asked for the $20? Mr. Wiseman.
Doesn't he say he needs it right now?
Because he says what?
He says he needs the money like right now.
Well, that's what Stanford. No, what does Booth say? Booth.
It's child support month and that.
I can't give you the 20 because it's child support month. Now, that's good. At least Booth is paying his child support. But I think we can infer that he did not have the most successful law practice in Oklahoma City from the fact that he can't come up with $20 even though it's child support month. Okay? So it's another reason you should not aspire to be Mr. Booth in your legal practice, because apparently his was not very lucrative. Okay? He says, come to my office later and I'll give you a check. Now, if you're willing to take Booth's check, you deserve what you get. But and then he says, Stanford, Anthony, the police officer, says, Stanford told Booth the thing was hot, and Booth says, I know how to handle things like this. Don't worry about it, Charlie. Why is that significant? Not to the outcome of the case, but why would that be important testimony if you were the prosecution?
Because it showed that Booth knew it was stolen.
And what is that knowledge relevant to?
Knowingly, like intent.
And mens rea, right? That's part of the mens rea that the prosecution would have been trying to elicit, that the knowledge on Booth's part that the coat was stolen, or at least had been stolen. Okay? So Booth takes the coat out to his car, comes back in, and then into the house. Anthony gets a search warrant for Booth's premises, kept watch on Booth's home till he arrives. So Anthony, the police officer, actually gets to Booth's house before Booth does. He's waiting for him with the search warrant, and he arrested Booth and again recovered the coat, and all's right with the world. Everyone in Oklahoma City has the top coats they're supposed to have. So what was Booth first charged with?
Receiving stolen property.
Receipt. Whoa. See letter H. Goes back. Receiving stolen property, i.e., the top coat is the stolen property. Okay, what does the trial judge do with that charge in terms of instructing the jury?
Yeah, at the conclusion of evidence, he gave the jury the instruction for attempt. So
He says to the jury, you can only consider attempt. Those. Why? Why does the court say to the jury, yes, he was charged with actually receiving stolen property, but you may only consider convicting him of attempt?
Property was no longer stolen. at that time.
Because property, top coat, wasn't actually stolen when Booth received it. I mean, it's kind of intrinsic to the charge, receiving stolen property, that you have to receive property, right? And that it has to be stolen. And if it wasn't, and why wasn't it stolen, Ms. Clements?
Because it
louder.
wasn't given back to the owner, but the police had taken it back into evidence.
It had
So-
been restored to its owner, and when something is in the possession of its owner, is no longer stolen, right? The crime isn't receiving previously stolen property; it's receiving stolen property. So the trial judge says, no, you can only consider attempt, and the instruction told the jury, with regard to that, that he would be guilty of attempt if he had the intent to commit the crime. Any problem with that?
No?
Right? The established intent based on his meeting, the testimony of Anthony that he was told it was hot, not even stolen, right? He has to have intent to stolen the property, and he committed a direct but ineffectual act done towards its completion. And preparation alone would not be enough, right? And we've seen that, right? You have to have the intent, so we've had and a substantial step towards completion. That's sort of model penal code-ish in its instruction. So the trial court concluded that the good to be receiving stolen property, the good had to still be stolen at the time it was received by the accused. Okay, that leads to the question, or what question does that lead to? I'll put it as a question to you. What question does that naturally lead to?
How can you convict somebody of something that wasn't?
I beg your pardon?
How can? No, wait. I'll rephrase that later.
How can you be charged with an intent to do something that didn't exist? I don't know how to say that better.
How, if it can't be
If it's-
receiving stolen property because it wasn't stolen property, can it even be attempt? Right? The very premise of the trial court's decision to not allow the jury to consider this leads the defense to say, well, then it can't be this either. And if you were Booth, how would you argue? How would you articulate the position that it can't be attempt either, and that any conviction for attempt should be overturned? Wanda?
If the charge that I was not guilty of was not criminal, then the intent isn't either.
Go ahead.
That was.
Hit me with it again.
If what I was really charged with was not possible, was not criminal, I think I'm missing some words, but then the intent isn't either.
How does Booth say the courts should assess the question? What question needs to be asked?
Is it a legal impossibility?
Well, yeah, but that's sort of assuming what I want you guys to sort of articulate to me. How do you look at his act, and what does that lead to?
Was it an ineffectual act done toward a commission of a crime? And if the property wasn't...
What do you mean towards commission of the crime? What does Booth say is the problem with his act, or what is insufficient about his act that means it wasn't even, not only was it not receiving stolen property, it wasn't even attempting to receive stolen property?
Is it that he says that if you can't be convicted of the substantive act, then you can't be convicted of the attempt either?
Why not? That's what I'm getting at. You're exactly right. Now, why not?
Is it because it wouldn't have been criminal?
I beg your pardon?
Is it because it would not have been criminal? Because
Even
it was stolen?
if-
It wasn't actually stolen because it never stolen.
If the act wouldn't have been criminal if completed, this is Booth's argument. Then the attempt to do it, the act, the it here is the act, could not be an attempt. Or the act of doing it could not be an attempt. You have to actually, he says, the way to think about this is look at whether it would have been a crime had it been completed, and if not, the steps towards it can't be an attempt to do the crime. And why wouldn't have been a crime if completed, Mr. Williams?
Because if he received it, actually, then that's not criminal.
I beg your pardon?
If he received it actually, then it's not criminal.
Why not? That's what I'm
Oh,
getting at.
oh,
Why not?
why not? Because it what the code had been returned to its owner
The
and
code had been returned to its
kind
owner.
of given
Okay.
back out again.
All right. So if you take this premise, if the act wouldn't have been criminal if completed, then attempting to do it could not be an attempt. Then what about the empty pickpocket cases discussed on page 749? What are those cases? First tell me what those are about
Those are.
before you give me the answer or tell me, if you're gonna go for a distinction, Mr. Smith, I don't want you to give me the distinction yet. Just tell me about those cases.
Those cases are where somebody intends to do an act and goes through with
What act?
a criminal act.
What particular criminal act?
In this
What's
case-
involved in those particular cases?
I'm not exactly sure what you're asking. I'm sorry.
I mean, there's not just a crime, that's an abstract. That's what crime was involved, Mr. Webb. Theft of? What do pickpockets try to steal?
Money,
Wallets,
wallet.
right? If you're a pickpocket, you're like on the streets of London probably. That's sort of what these cases arise from. And the question is, and what creates the seeming impossibility of successfully completing the crime in the empty pickpocket cases?
Even if they reached in the person's pocket.
Why not?
They wouldn't steal anything.
Because?
There's nothing there.
Because
There's no wallet.
there's no law. Oh, you're my favorite person ever. Thank you. Okay? Because if you reach in, you're a really bad pickpocket. Okay? You're a really bad pickpocket. You reach into empty pockets and go get wallets, right? And what would the defense argue, Mr. Smith, in those cases?
That it's a. Should I say the distinction?
No, just tell me, without a distinction, what would it be if you're trying to steal a wallet? What would it be if you reach into an empty pocket? It would be what to achieve that crime, to complete that crime? I'm sorry.
It would be attempt.
It may or may not be attempt, but it would be impossible.
Okay.
Right? I don't want to get at the kind of impossibility, because that's the distinction. It'd be impossible to commit the crime. Just like Booth is saying it's impossible to commit the crime of receiving a stolen code. So my question is, if it's impossible to commit attempt as Booth, because the code was no longer stolen, then it would seem like it's impossible to steal wallets when you reach into an empty pocket, and you also should not be able to be convicted of attempt. And that is, that's much better. Impossibility is impossibility. And therefore it precludes attempt. So therefore we would suppose that given the outcome of Booth, that in the pickpocket cases, the pickpockets would also walk. They would also not be convicted. Is that right, Ms. Richter?
No, because in the one.
Well, I beg your pardon?
In the pickpocket case, it
Just
didn't.
answer my question.
Okay.
Is that right?
No,
Do
it's
they
not right.
get acquitted or get their convictions overturned?
That's not right.
I'm sorry?
That is not right.
That is not right. Pickpockets who reach in to empty pockets, i.e. find no wallets, are, at least according to the common law, guilty of attempt. And therein is our conundrum. How can it be that empty pockets produce attempts, but no longer stolen top coats do not produce attempts? And with all that now set up, does the outcomes seem different when they both seem to result in impossibility of completing the crime? Mr. Smith, what is the difference?
Difference is a legal impossibility and a factual.
Legal versus factual. Explain that to me, if you dare.
A legal impossibility shows that even if the circumstances were the same and the act that somebody was doing is completed, it's not a criminal act.
It's in the legal, there's a legal distinction between a stolen top coat and a not stolen top coat, right? It's whether the law renders it impossible. Right? This is, right, top coats are top coats are top coats. They're all if you see a top coats hanging in a store, and they were all 10 of them were in a row, and one of them had been stolen. You wouldn't be able to tell which one. It's not about the facts. We attach a legal character to that, okay? Is there anything, in the case of the empty pickpocket, what makes it impossible?
The fact that there's no wallet.
The fact, I like the way you said it, that there's no wallet, right? It's not that the wallet wasn't, there's no legal character to it. It's just, was there a wallet there, or was the pocket empty? And the law said this means there cannot be attempt, and when the only reason it's not a completed crime, or that it can't be a completed crime, is because of the factual circumstances, it can be attempt. Okay, and the court applies this on 750. It says the code had lost, because the code had lost its character as stolen property, legal impossibility precludes the defendant from being prosecuted for the crime of either receiving or attempting to receive stolen property. And then the court says something, okay, we got that distinction.
Okay.
We'll talk about whether it makes sense, etc., but we got that distinction, right? Then the court says something that just throws everything off the rails. The court says, in justification of this distinction, that it is fundamental to our law that a man is not punished merely because he has a criminal mind. If you were the prosecution and you saw that in the defendant's brief on appeal, what would your response be? What would your response be? It's called.
The defendant had acts that corroborated the intent. Whenever he went to the thief's house and tried to get the coat.
So
there was a substantial step.
there was excellent. There wasn't just a criminal mind. We're not. If I was the prosecution, I would say, judge, or in my brief in opposition to the defense, I would say, this prosecuting and convicting Mr. Booth does not punish him merely because he has a criminal mind, but because he has a criminal mind and acted on it in a substantial way. What more do we need for attempt? Right? So the court says, as a justification for not punishing legal impossibility, this is awfully shaky. Awfully shaky. Because the law really isn't doing that at all. Okay? So, Ms. Harper, you had a question?
Yeah, I'm just trying to make sure I have the distinction between legal and factual correct. If it's factual, that means there was a fact within the case itself that prevented the crime from being completed, so there can still be a charge of attempt. And
there can still be a charge of it. There is nothing in, if all the defendant can point to is something in the facts and nothing about the legal rules that applied to the facts, that it was the facts that made it impossible. I could not commit theft as a pickpocket because there was no wallet in the pocket.
okay, and then so for legal, because the coat was no longer technically stolen because it had been restored to the owner, it's legally impossible to charge with the act itself or even the attempt of the act.
That's right. That's
Okay.
right. We're only talking about attempt here.
Okay.
Right? We're only talking about attempt here, and a factual impossibility, you can charge attempt with legal or convict of attempt, and legal impossibility you cannot. That's the common law rule. The common law had a long-standing, well-established distinction between legal and factual impossibility. What does the MPC have to say about this distinction?
They don't distinguish between.
They do not distinguish. So if those of you who think, and I personally think, that the distinction is utter rubbish, the MPC is just up your alley. The MPC says in section 5.011 that there is no distinction between the two kinds of impossibility. What does it say, Ms. Clemens? What rule does it create?
Well, with either one, you would be guilty of attempt.
Well, but what rule does it establish? I know that that's the result, but what is the actual rule, Mr. Razor?
They purposely engage in conduct.
I beg your pardon?
When they purposely engage in conduct, and it would be a crime if the circumstances where they believe it to be.
Well, you say purposely as if that's the only mens rea. Does it say this to be purposely?
When they have the intent,
I'm sorry?
when they have the intent, or is guilty of an intent to commit a
It says
crime.
with the culpability otherwise required for commission of the crime. So if the crime itself, the successful crime requires records, then you have to act recklessly. If the successful crime requires purposefully, then you have to act purposefully. So if you act as the attemptor with the mental state that was otherwise required for the crime, then what do you have to do? What's your actus reus?
Purposely engaging in conduct, which would constitute a crime,
Which what?
would constitute a crime
If?
if the circumstances were as you believe.
Exactly. If the attendant circumstances were as you believe them to be. Whether those attendant circumstances are legal or factual. That is the catch-all term that applies to either of these that were treated differently in the common law. So you say, okay, what did the defendant think the circumstances were? And if the reality had been that, and it would have been a crime under those circumstances, the defendant is guilty of attempt. So apply that to Booth, Mr. Razor.
He believed the coat to be stolen.
Good. So that was the attendant circumstances. And if the attendant circumstances had been as Booth believed them to be,
He would have been charged.
and so he is guilty of attempt. Perfect. Right? And he believed the coat was stolen, so you look at, what were the circumstances as the defendant believed them to be? We know he was wrong, otherwise it would have not been attempt. Right? But we create that fiction. If it had been that way, would it have been the completed crime? And if it was, or if it would have been the completed crime, then it's attempt. Now somebody apply it to the pickpocket cases. What did the pickpocket believe, Mr. Razor?
He believed there to be law.
He believed there to be law, and that's what the attendant circumstances were. And if the circumstances were as the pickpocket believed them to be, would it have been the completed crime of theft? And so is he guilty of attempt? Yes. See how the distinction collapses under this rule? Questions. This rule is a blessing. Right? Look upon it as the greatest gift the criminal law has ever given to you, because it makes things so much easier. All you have to do is say, look at what the defendant, if the prosecution can prove it, what the defendant believed the circumstances to be. And in the pickpocket cases, it has to be somewhat by inference, right? We can infer from the fact that the pickpocket reached into the pocket that he or she must have believed that there was a wallet there, otherwise why? Right? So yes, we have to infer that, but then if the defense wants to contest that, they can contest it. But if the prosecution can prove that the circumstances were as the defendant believed them to be, would have been a crime, then you've got attempt.
So is the use of the word purposely that's in a couple, like part A and C, that, is that used in a different context?
I think you want to focus, for purposes of the mental state, on the first part of it is about the crime, the underlying crime. Did you satisfy the mental state that the crime requires.
Okay.
And then the purposely refers to engaging in the conduct,
Yeah.
okay? One.
I'm pretty sure I'm missing something, but I just couldn't help but think of Rizzo. Like, I felt like wasn't this a similar situation to Rizzo where like it was the factual impossibility that he committed the crime because the person he was looking for didn't show up, but you know he still was kind of.
Well, remember, in Rizzo, we were only asking for that, for purposes of that case, whether they had committed the act of attempt, whether they had come close enough under the dangerously near or dangerous proximity test. But if we're going to apply this question to Rizzo, what do you think the answer would be? Was it legally or factually impossible? Factually impossible, right? There was nothing in the legal status there. It was only the facts that rendered it impossible. They couldn't find the person with the payroll, etc. Okay? So under the common law rule, what would, given, if that were the only issue, let's say they had come dangerously near, so that wasn't a barrier, but it had been factually impossible. Under the common law rule, what outcome? What's the outcome?
No, wait, sorry, factual.
Factual. Would have been convicted. So you can have, under the common law, you've got either one could be the defense's out. Either factual impossibility or I didn't come dangerously near. Those are two separate issues. You have to look at potentially both of them, right? Under the MPC rule, again, let's assume we only need a substantial step under the modern approach. Do we, under the circumstances as Rizzo believed them to be, Rizzo believed that he would be able to find the payroll, and he took substantial steps. So I don't think it would be a barrier. Okay? How many of you like the modern rule a lot better than the common law rule? So since you like the model penal code rule, let's apply it to the best case we're going to read all semester. Navy. There's a lot of good candidates for that. New York had, in fact, in 1967, amended its penal code to adopt the model penal code rule. And it sort of tells you something about the changes in the law and how courts respond to them, that at the time of Dlugash, the New York Court of Appeals says that this revision was novel, that the revision and its approach to impossibility had been revised in a novel fashion. It's not so novel anymore, but to judges who were sitting on this court who had grown up with this distinction, they would have been like, this is a revolution, okay? And with what is Dlugash charged?
He's charged with murder.
A little louder?
Murder.
Murder? Oh, yes, that's right. Yes. Dlugash is charged with murder. And how is that? Or what were the circumstances?
So there were three guys in the compartment of the Geller, and they got in an argument about rent money.
The argument was actually between Bush and Geller, right?
Right.
Okay.
And they got in an argument about rent money, and so Bush shot Geller. He shot him 3 times in the chest, and then.
Bush shot him in the chest?
Yes. Bush shot him in the chest.
There was only one bullet in his heart, right?
I thought one through the lungs.
I beg your pardon?
I thought one went through the lungs too.
Okay, good. All right. And Geller had demanded the rent. Bush said, you better shut up or you're going to get a bullet. And one thing we can say about Bush is a man of his word. Okay? And eventually Geller made the mistake of saying one more word. And so Bush drew his pistol, it was the .38, and aimed it at Geller and fired 3 times. But Bush is not our defendant, who is Dlugash. So what then happened that brought Dlugash into all of this?
so about 2 to 5 minutes later, he decides to shoot Geller's body that's laying on the floor 5 times in the head. And he said that Geller looked dead when he shot him.
Lou Gash shoots Geller 5 times, even though he says Geller, he believed, was already dead. Then what happens? What usually happens after shots ring out? I beg your pardon?
The police come.
The police come. Now, Ms. Hall, I want you to be the police for me for a second. You're the police officer who arrives on the scene. And you ask Dlugash, what happened? And Dlugash says, I shot a dead person. Oh, by the way, 5 times. What is your natural question as a smart and experienced police officer going to be?
Why did you shoot a dead person?
Why did you shoot a dead person? Because it really doesn't seem to make much sense. If nothing else, it's a waste of bullets. Why did you shoot a dead person? And what did Dlugash say?
I think he just said, I don't know.
He said, I don't know, and then? Gee, I really don't know. That's great. But then he did give an answer.
He said that he was afraid of Joe Bush.
He was afraid of Joe Bush. So the prosecution has charged Dlugash, you told me, with what?
With murder.
How can you, but you can't kill a dead person. So the prosecution must have a theory. What's the prosecution's theory in charging Dlugash with murder?
They had 2 expert witnesses that testified that he might still have been alive at the time he was shot the second time.
He was still alive. And they have medical experts come in that it might have taken quite a while for Geller to die from Bush's shots. And therefore he might have still been alive. What's the problem with that evidence?
That it wasn't beyond a reasonable doubt that he was still alive.
Because there's testimony that, and even the prosecution's witnesses couldn't say that he was alive with medical certainty, and the defense puts on evidence that it might have taken that it might have been instantaneous or very quick. And so what does that create? On the issue of whether Geller was still alive, what does that create?
Question of fact from the jury.
A question of fact, and more importantly, from a point of view of convicting him? I'm sorry?
Doubt.
Reasonable doubt. Right? So we have reasonable doubt. That's the prosecution's theory, but there's reasonable doubt given the evidence available to us. And if there's reasonable doubt, you cannot convict him of murder. And that's what the Court of Appeals says. The Intermediate Court of Appeals reverses the murder conviction. Okay? Says the prosecution didn't prove beyond a reasonable doubt. He might have been, but did not prove beyond a reasonable doubt that Geller was alive when Dlugash shot him. Okay? And the Intermediate Appellate Court says, well, what about attempted murder? What is the intermediate, not the Court of Appeals in this case, or in the case we have here, in the opinion we have here, but the Intermediate Appellate Court here says something about modifying the verdict for attempt. What does it say?
They said that the jury couldn't find that he had done murder, but that they could find that he had the intent to kill a living
That the jury
human.
couldn't find that he had the intent. That's what the Intermediate Appellate Court says. The court says the uncontradicted evidence is that the defendant believed him to be dead, so he lacks the mens rea to kill, right? You have to act with the intent, with the culpability required for completion of the crime. So if he believed him to be dead, then he wasn't attempting to kill him, says the Intermediate Appellate Court. Very good. that brings us to the New York Court of Appeals. New York just wants to confuse everything by calling its Supreme Court the Court of Appeals, which you would think would be the intermediate appellate court, and the Supreme Court in New York is actually the trial court, because New York's concocted. What are you going to do? All right, so what does the Court of Appeals say about the murder conviction first?
They agreed with the lower appellate. They said that he couldn't be convicted of murder, as they did.
Because there was not proof beyond a reasonable doubt that the deceased was still alive. Then it turns to the possibility of attempted murder. And what does it say?
That he could be held criminally responsible for attempting to kill a victim, regardless of the fact that he was alive or not.
Why? What could the jury have concluded? We're going to ask two questions here. What could the jury conclude based on, was there enough evidence of it? And then we're going to ask, what did the jury conclude? So give me that, let's address that first one.
They concluded, or they could conclude that he had the intent to commit
Because?
murder.
That he had the intent because
He had reasonable belief that he was still
Because?
He had reasonable belief that he was still alive.
that he believed he was still alive. The jury could have concluded from the evidence that Blugash believed Geller was alive. Right? And the basis for that, if you're the prosecutor, in one easy sentence, what would be your argument that there was evidence from which the jury could have concluded that Geller was alive? That Blugash could have believed that?
Well, he said he believed him dead.
I'm sorry?
He said he believed that he was dead.
Well, he said he believed he was dead. That's the defense's argument. What's the prosecution's counter argument? He shot him 5 times, Your Honor. Right? The jury could certainly infer from that you shoot somebody because you're trying to kill them, and you're not trying to kill them unless you believe they're still alive. Right? Because there's no need to kill a corpse. Right? So there's certainly evidence, just from Dlugash's own actions, that would permit the jury to conclude that Dlugash believed Geller was alive. Okay, that makes it a permissible conclusion, but what would be the result if all we could say was that the jury could have concluded that? What would be the next step?
You're saying like the other thing that the jury could conclude?
No, I'm assuming if that's all we can say. What would be the next step procedurally? What would have to happen next? I beg your pardon? No. What would have to happen?
If you're at this court level, wouldn't you have to send it back down?
Because all we know is the jury could have concluded that, but the jury didn't conclude that. At least, right, we haven't looked at the second question yet. And if all we can say is the jury could have concluded that, we have to say, okay, let's let a new jury decide. Was it attempted murder? Did Dlugash actually believe Geller was alive? So now our question is, do we need a new trial? Can we say anything about what the first jury not only could have concluded, but actually did conclude? And what does the New York Court of Appeals say about that? Call?
Because they found that he had intent to murder, he had the intent required for a sentence.
The murder conviction tells us all we need to know. And that is, the murder conviction is, what is inherent in the jury's conclusion that, oh, Dlugash committed murder?
That the victim was alive.
I beg your pardon?
That the victim was alive.
That the victim was alive, and more importantly, for our purposes, he believed it. That he believed it. If you're going to convict somebody of murder, and with the mens rea of intent to kill, it's inherent in that. The jury did conclude that Dlugash believed this, and if Dlugash believed it, what do we do under the model penal code? What question do we ask?
Well,
the attendant circumstances?
Not what were the intended circumstances
Were the attendant circumstances as he believed them?
as he believed them. So the intended circumstances as he believed them to be were that Geller was alive. What can we convict him of?
Attempted murder.
Attempted murder. Everyone see this? Questions? Alright, so it procedurally gets messy because the jury convicted of murder, not attempted murder. But if you put that aside, let's just assume all this happened at the trial level, and the jury had been instructed, and he'd been charged with attempted murder. Ladies and gentlemen of the jury, to convict Lugash of attempted murder, you must find that under the attendant circumstances as he believed them to be,